My friend Peter has a question.
Yeah. Well, at first I actually have a comment. It's kind of a practice tip for the in-house lawyers out there, and if you're in private practice, maybe you can share it with your in-house folks. It's interesting that even within the European Union there's so many differences. And one of the things we try to do at Box is really recognize those and develop your policies and procedures around the specific jurisdiction. So in the UK, you know, maybe you want some type of kill switch on your network, right? And I'm serious, because you have, in certain jurisdictions, they can come in and grab a laptop. Well, you want to make sure that those employees in that jurisdiction have encrypted laptops. So you need to kind of learn what the specific rules and laws are, and where you have some potential issues. And you need to kind of plan for that ahead of time. And we do that through a matrix, and we really sit down with our local attorneys and say, you know, is this okay to do in this jurisdiction, or we're going to get into trouble because we're now stepping in front of the police agencies. And in a lot of cases, we can actually manage through that process. So it's interesting just finding, you know, in some cases, not so subtle differences in jurisdictions. So the next question is, what is required for law enforcement representatives to obtain access to material they need for their investigation?
Yeah, well, basically, the warrant procedure proposes that affidavits be proposed in which, depending on the object of the inquiry, you'd have to demonstrate that other non or less intrusive proceedings were tried and unsuccessful, that you have probable cause that a criminal act has been committed, or that you may prevent future criminal activities of an organized crime group. In certain instances, for example, Canadian Security Intelligence Service officials, they also need to go through the approval of the Minister for certain extraordinary warrants, if you will, that can lead to access or obtain pretty much anything. The law actually uses the word anything, which is uncommon to use such broader terms. So it would entail record, well, data as a whole, and support infrastructure also. In those instances, so there's a double filter. You know, the last guy in the house cannot decide to pursue an investigation on his own intent. So there's an inside process also. Otherwise, it would depend on the nature of the investigation. For national defense purposes, which uses, you know, any danger to the national security of the country, it just needs the authorization of the minister. So they have to go to an elected official, which has a consulting committee also to be addressed. But the law provides that under circumstances where the national security is in jeopardy, if you will, they can intercept private communications without going to a court. So, but mostly they would, you know, order of production or warrant, you need probable cause, facts relied upon, and affidavits by the person in charge of the inquiry.
I'm sure it depends on the type of process, but typically kind of timing on that.
Oh, the timing?
It takes, yeah, from a request to.
Obviously, for, you know, what the Canadian Security Intelligence Service does, we have no data. But, you know, if we parallel what, you know, the criminal court systems would allow, it's private, it's ex parte. So, you know, we're talking days or hours mostly. Obviously, the law provides for the use of telecom and electronic means to, you know, present the request and obtain the warrant also. So there's no, you know, geographically we're pretty much as extended as you can, although we're all massed next to the border. Anyways, so, you know, we're talking days or hours for matters of national defense. Quite frankly, we have no information. There are some reports, the wiretapping data that you see it's information that's disclosed on a yearly basis, but the activities of the Canadian Security Intelligence Service, there's two reports. The interesting one, which is secret, and the public one, which pretty much is called operational report on operational measures, but it's, you know, they'll tell you what, you know, the Globe and Mail said last week, pretty much. What's in the press?
Yeah, in the UK, I briefly touched upon that there's no need to get a judicial order, which makes it quite swift. The police forces can self-authorize under the REPA Act, which is obviously makes it very swift for them. You know, you can go in terms of interception. In theory, you could and should get a warrant, or they should get a warrant from the Secretary of State, but the police do self-authorize, and as I say, local authorities did have access, but that's now, as of just last year, that's been withdrawn from the local authorities. I think it's very important in terms of some of the lessons to be learned here is that your you know, terms and conditions, you know, allow you on a contractual basis and recognise the fact that you may be either as a service provider of a cloud or the host company to disclose that information. So you know, I think that's a lesson which will come through the course of today in terms of ensuring the terms and conditions allow for it. As Jean-Francois mentioned, you know, even though they do have access, it doesn't always mean that the use of data obtained during that process will be necessarily lawful and accepted by the judge in the criminal proceedings. And just one other factor just to mention while I want it, it's not necessarily strictly, it's in terms of terms and conditions and dealing with the issue of collateral damage, I think, which we'll probably discuss on later in terms of, you know, talking about the seizure of a laptop, or you know, if you're disclosing information about one particular user, it may be in the course of handing over that data in terms of lots of other people will be handing it over. Anyway.
Okay, in Switzerland it's the same. You have a prosecutor who is asking a judge, that's called Tribunal des mesures de contrainte, an order to be able to control the data, to access these data. But I want to explain something perhaps special for you, but in Switzerland cryptography is not forbidden. You can crypt everything with any key you have, so that our customers in the whole world, they immediately ask us, how do I need to manage my data? Can I crypt them? If they ask me the key, should I give this key or not? You shouldn't in Switzerland. It's not an obligation. So we crypt all the data. Nice country, yes.
Yeah, it's the same. The protection against self-incrimination was established that it protects you against providing an encryption key,
okay,
a decryption key. But there's some discussions around that because that's costly.
Yeah, and so this is the first important information. The second information is about the transparency rules. We have really developed transparency rules, and so when something has happened, if you have been under control or someone has asked to access your data, you will know it. It won't be something that doesn't appear in a case. We have had a lot of really important cases that are public cases. Perhaps you remember Razorback case, that was the most peer-to-peer case in the world. We have won this case against the MPAA, and they have tried to go to the data in the whole world to understand how it was working. But in the end, these informations they got by a company, a US company, they were declared illegal, and they couldn't use it, even if it was a criminal case. So the rules are really precise, and you cannot do what you want to make the things without the accord of state. We have had a company that's called, it's a famous case, Logistep in Switzerland. It was a case in whole Europe where they decided to track the IP addresses, and we won. In this case, we won before the High Court of Switzerland, and IP data were considered as protected data. You cannot track IP data. And so even if the case is really important, you need to ask the judge. You cannot manage the case as you want. I have a company that is able to get these data. Should I ask this company to do it? And after I give the data to the police? No, it's not possible, because if you have a good attorney at law in face of you, it will be declared illegal and you will be prosecuted. So the rules are really, really formal rules.
But are there actually cases of intrusion upon privacy pursuant to illegal detention?
Yeah.
Okay.
They were condemned, and it was totally crazy, because this guy has gone to Germany with Logistep. It is a Techland case in France, and in the end of the audience, I asked the prosecutor to put him in a jail. He didn't understand, because it was declared illegal. So if he has taken a lot of data about the people who have downloaded, it was a game. It was a game, a computer game. He has to leave Switzerland really quickly with the whole company. In 24 hours, the company has gone to Germany, because it was totally illegal to get these data, and the court has told him, perhaps you're right about the case, but you shouldn't do it like this.
In Canada, there's a section that says you can't use a computer system on if you're not authorized to do so, but it's, I'm going to use the word seldomly been used, but my instinct leads me to believe that it's never been invoked. So our problem is you're going to spend money in the inquiry, you might not be able to deduce this evidence in a court proceeding. So that's a
to follow up just briefly on what Sebastian said, the rules are the same in the US. Not only do we have pages and pages and pages of rules, but if you don't follow them and you then prosecute the case, the case is going to be thrown out. The prosecutor has to be able to bring data that has been collected according to the rules. So there is a very strong incentive to follow whatever the zillion pages of regulations and laws that we have, so similar to you.
In Italy, it's much like in the other countries, and as Jean-François was saying in Belgium, the investigation is really, well, actively is made by the police, but it's under the control of the judges. So the judge, the public prosecutor, which is the equivalent of the district attorney in the US, is the one who manages the case. So the police cannot do anything without informing the judge or obtaining an order from the judge. The second point I'd like to make also is that this order can be immediately appealed. So let's assume that the judge issues the order and you're bound to give the information. If you appeal and you want an appeal, then that information has to be returned and cannot be used anymore. So it's a process which is quite quick actually, and you can, at the same time going to the Supreme Court, even if you are still in the investigation phase. So it's pretty much protected. And the other thing I wanted to say, coming back to what Sebastian was saying, there was a similar case in Italy. This was a civil case. It was the Peppermint case. It was a German company who tried to get the IP addresses and names of people who were downloading music or videos and so on. This company went to a local judge in northern Italy, and I don't have the faintest idea why they went there. The judge issued an order ordering the telephone companies to give the IP addresses and so on. This order was immediately appealed, and in 6 months went to the Supreme Court, who just slashed it down and totally reversed what the judge said. So, because those were personal data, and there was no way that a private guy, a private entrepreneur could get access to those data in such a way. So from the point of view of protection and of the means of stopping an order of that kind, you're pretty much safe in Italy. Because I said, if you go to appeal and you win the appeal, once you win the appeal, you can do whatever you want with those data, and the judge can never use them anymore. So it's
well, in France we have the same rules. In Italy, and this is comprehensible as we are both Latin countries, and we have the same sets of rules coming from Roman laws and Napoleonic Code. So we have the same rules. But one thing I wanted to stress is that in some cases, security interceptions, when national security issues are important to be safe. Security interceptions can be ordered, can be realized without any judicial or court control. And like it is the case, I think, with you in Canada, you have just to ask the minister the authorization to wiretap and to proceed to those security interception, and there's no control on that. And there's no report.
No, you know the rules for the citizen, maybe for the state security, the intelligence service in Belgium are more free. The specific method can only be implemented after written and reasoned decision of the head of the service. It's not an independent authority, it's not the head of the service. And after a notification of the decision to the Commission is more independent, is an administrative body responsible for monitoring intelligence services. And it's only for exceptional methods like trespassing, hacking, wiretapping, the Commission must give its prior consent.